it basically just looks like a classroom, right? There's a lectern at the front where the prosecutor sits. There's going to be a seat for a witness, usually a bunch of multimedia apparatus so that you can put stuff on a computer and throw it up on a projector screen. And in Massachusetts, it's being used to record you. It's a bunch of people. They're usually at chairs with desks so they can write stuff down. And then what you're probably driving at, no judge, no defense attorney. It's just the prosecutor and the witness. There's always a grand jury coordinator, like I said, who works for the DA's office. They control everything from an administrative perspective.
So you get them there, you're in the classroom.
Yep.
Prosecutor, witness, PowerPoint up of the evidence. The 20-something grand jurors are there. In the petit jury of a regular criminal trial, they're trying to decide not guilty or guilty. What is this grand jury trying to decide at that point?
Probable cause to indict. Yeah, which again, I mean, is really worth driving home for folks. It's less than 50-50, right? So it's reasonable articulable suspicion, probable cause, preponderance, clear and convincing, beyond a reasonable doubt. And the only one that has a real like statistical association with it is preponderance, right? It's more likely than not. So 50.1%. Probable cause is below that. So
it's not even likely.
Doesn't have to be more likely than not. Just has to be, something that a reasonable person would believe.
Welcome back to Boston Barristers, everybody. The legal podcast where we break down what's really happening in Massachusetts courtrooms. No legalese, no lectures, just real talk from attorneys who do this work every day. I'm your host, Bill Manchinton, criminal defense attorney here in Boston, and I'm joined by Chris O'Brien. And we have a great podcast today for you because we're diving into grand juries, how they work, what happens inside that room, and what it actually means for someone who's being investigated or called to testify. And to walk us through it, Chris here, senior trial counsel and a former prosecutor, he's going to explain it all because he has been in front of more juries than I can count, and he's seen the grand jury process from every angle, prosecutor and defense. So Chris, thanks for being here.
Thank you for having me, Bill. I appreciate it. Maybe I'll start by offering the sort of containment that I can. There are people who have way more exposure to grand jury than I do. I know because I worked with a bunch of them when I was, either a assistant county attorney in Rockingham, New Hampshire, or when I was an assistant attorney general at the Massachusetts Attorney General's office, when I did mostly fraud work in the criminal bureau. There are people who, career prosecutors, they just live in grand jury. I knew someone I worked with who, when I say he lived there, I think he spent more time in front of the grand jury than he probably did in his office. So, hopefully I'll give you all a sense of my experience. So one of the things I have to offer is that I don't think many lawyers have probably been in front of a grand jury. I mean, so there are those of us who have, some probably don't do it very often, but there are some who do it way more than I do. What I probably offer is I've been in front of a lot of different grand juries, like in different counties and different states, statewide when I was at the AG's office, which is sort of a different animal, but I can hopefully give some insight, about the purpose of the grand jury. What does it mean to be in front of the grand jury? What do we do? What's the business? Thanks for having me. Hopefully I can give you guys and some of our viewers some of the benefit of my experience.
Yeah. All right. So let's just jump straight into it with some basics. So what actually is a grand jury and how is it different from the jury people see on Law and Order?
So my understanding, and this is funny, we promised no legalese. I'm going to break that right away. Sometimes people who have been practicing for like 50 years will say petit jury. And my understanding is petit jury is just not a grand jury. But a petit jury is the one you're going to see in Law and Order, right? The petit jury is, and it's a smaller jury.
Because petit's small in French, right?
Right, versus grand, right? I guess that's, I don't know, etymology, but I think that's got to be the general understanding, right? So you and I know district court in Massachusetts, you're going to have 6 jurors and an alternate. Superior court, you're going to have 12 and 2 sometimes, 12 and 1. I guess it's, up to the judge, it seems. And then a grand jury is going to be a fair bit bigger, right? I think to have quorum, you need 13 people, I want to say. But, usually there's going to be upwards of 20. And to get a grand jury to indict, you do not need unanimity, which is one of the things that differs from a petit jury, where you can't convict someone beyond a reasonable doubt unless all the jurors are unanimous.
So let's talk about that real quick. So the normal jury, the petit jury, petite jury, whatever we're talking about here, like the one you see on TV, all right?
Yeah.
That one, they are trying to find you guilty of a crime at trial, right?
Yeah, they're going to hear
So
evidence. They're going to get instructions from the judge. They're going to say whether
guilty
you're
or not
guilty or not
guilty, right?
guilty. Yeah, or mistrial, I
So
guess. But
where does the grand jury come in?
way sooner. So
Okay.
I think that's
All
a
right.
good way to envision it. Probably the best way to describe this is a lot of crime you can imagine is going to be immediate, right? So something happens,
Okay.
police are called. Let's pick something fun like a bank robbery. I guess it's not fun if you work at a bank, but
Yes.
someone robs a bank, they call the police show up, and maybe they catch the bank robbers walking out the front door, put them in
Mm,
cuffs, and there's surveillance footage. They've got the folks walking out the door of the building. There's really not a lot of question. Even in that circumstance where it's so serious, it's probably going to still end up. It's going to end up in front of a grand jury, but the charging process will begin immediately. They'll be brought to court. They'll be arraigned. There'll be bail hearings. But what's interesting is, and I think in a case like that, it's going to be so serious that it's going to get indicted. In order to be in superior court, you have to go through the indictment process. Um,
okay.
so I don't want to get all over the map here, but if you got caught shoplifting, you're not going to get indicted, right? Unless you
Okay.
shoplifted something fairly impressive. But you're going to be processed in district court. And, the evidence is what the evidence is, right? I mean, it's whatever they were able
And
to,
you
the
keep
police were able
saying
to pick up at the
indictment.
scene.
What that's just
Yeah.
like break that down. What does indictment
Sure.
mean?
So an indictment, I appreciate the clarification. The way that a due process essentially starts, give or take, is that you are alleged to have committed a crime. At a lower level, we call these generically charging documents, right? We criminal prosecutors and defense attorneys. Charging document is the thing that says you're accused of this crime. And it could be a complaint, which is kind of the lower form of it. And I say lower because it really is just something that can be filled out and signed. Um,
Okay.
and it's based on probable cause. Is probable cause to accuse you of this crime. And, probable cause standard has different definitions, but the one I always learned was facts and circumstances lead an ordinary person of ordinary prudent caution to believe. Probable cause matters, though, because it's going to be the same standard at a grand jury. But
Mm,
the complaint is the beginning of the process, more or less, like legally, right? I mean, you talked
okay.
about law and order earlier, right? There's the police
Right.
component. Then there's going to be the legal component. And the court component is going to start with the charging document.
Okay.
In a lot of cases, like I said, it's a complaint letting you know, hey, you're this person, date of birth, what have you, you're being charged, you're being alleged to have committed this crime. Sometimes it's a bare bones document. It's going to just copy paste the language from the statute. It's alleged that you did on this date, you did, and it's not what is
Right.
sometimes referred to as a talking indictment, but it's just going to be a bare copy paste of the statute.
And that's at the district court level, right? Like these
Yeah,
bare
and
complaints, it'll have like a police report attached to it, and then they just got to have probable cause, and then you get into your district court. But these indictments, that's for like the big boy stuff in superior court, you're saying,
well,
right? So it starts out in the
yeah.
district court, but then
So this is interesting, and at the risk, I don't want to confuse folks, but what can happen is because crimes that are like kinetic, like in the moment, the immediate crimes, you're not going to go say, okay, everybody hold on for a sec. I'm going to go get a grand jury together. I'm going to get an indictment, and then we're going to deal with the rest of this. You kind of get pipelined into the court process, and then it's sometimes called a bound over. There's like a lot of old terms for what it used to be referred to, but you essentially get transferred from the district court to the superior court once the indictment lands. There's an exception to this, which I think is probably worth getting into because it's the bulk of what I did my grand jury work on at the
okay,
AG's office, where the first part doesn't happen. The grand jury is just convenes in secret, which is always true. And then an indictment kind of just comes down. A person might have no idea they're in trouble. They might have no idea they've been investigated for a couple years,
okay.
and then they get
So we got two
indicted.
scenarios here.
Yeah.
One where it's like an immediate allegation of a crime and you're arraigned and you get put into the process of district court. And then because of an indictment, you get upgraded essentially to superior court. That's
Yeah.
scenario number one. Scenario number two is that this is serious enough where you just get indicted and you go straight to superior court. Is that correct? Those like the two scenarios?
Yeah, the qualification I would put on that is it's not always because it's serious enough. It's really has more to do with like the immediacy of the crime, right? So
Okay.
let's take it out of the abstract because it might make it easier to understand.
Sure.
What I did for 3+ years when I worked in the fraud division at the AG's office that I was assigned to, and even when I kind of branched out to other like white collar work I got loaned out to major crimes at one point, is you've been made aware, and it can be bank fraud, embezzlement, money laundering, whatever it is, that there is a crime going on, like an ongoing offense, but nobody's been arrested yet. I mean, maybe some folks have been arrested, but not everybody. So what you do is you use the grand jury as an investigative tool. This is kind of one of the more unusual aspects of it. I think it's not common in some district. I mean, it's not common in district court practice. I would say district attorney's offices, and I shouldn't say that because I don't know from Massachusetts. But what I'll tell you is, again, just going off my experience, I worked in the county attorney's office in Rockingham in New Hampshire from like 2018 to 2022, let's say. And I was in front of the grand jury like once a month for a couple of hours, and we would indict like dozens and dozens of folks. And it was non-investigative. This was the immediate stuff, right? So somebody gets arrested, they get pulled over, they get the police find a kilogram of fentanyl in the car, and you get arrested. That's kind of a lot of fentanyl. So you're arrested, you're probably held without bail, and because it's going to be charged in superior court, and there's going to be access to state prison time, you get indicted for that. So we go in, and the officer reads the report. And if there are no questions, I would read the indictment, which again, just a charging document, but it's going to say on this date, the person committed this crime through the following means. They were, knowingly in possession of fentanyl, et cetera. Like whatever the language is going to be, you just usually go by the elements. The flip side of that, using the grand jury as an investigative tool, it's like, again, more of what I did as an assistant attorney general, is you understand like there's an allegation, that this person, maybe there's like an investigation by another entity. And they say, hey, we think this person's embezzling from this charity they work for. And you're like, okay. Wow. We're going to authorize grand jury subpoenas. This is kind of I don't want to get into the weeds on this, but it is probably surprise people to learn how this is conducted. And I'm not giving anything away here. This is just the process. There's an allegation, and it's a strong enough allegation that it merits an investigation. We get permission to investigate from the office. We use the grand jury's authority to go to a bank and say, I want all this person's bank records, and I want the bank records for the charity. And then it's a pretty simple matter of getting a financial investigator to go, yep, there goes the money, goes from the charity to the person's personal bank account, and then they used it to pay their mortgage or for their car. Yep. This all happens in quiet. This person may still be doing it, and they have no idea they're under investigation. They have no idea the bank's turned over all their records. But what you do is you have to return the evidence to the grand jury. It's like the term is returned. You go to the grand jury and say, hey, grand jury, on your behalf, we pulled all these bank records because we had suspicion that a crime was being committed. And wouldn't you know it, crime was being committed. And this is done through witnesses, right? The lawyer is not going to testify to all this kind of thing. But what it means to be in the grand jury then is you're going to go in front of this group of folks who got impaneled the same way that a regular grand jury, a petit jury gets impaneled.
Yeah, so let's cover that basic aspect. Yeah. So it's around 20-ish people. And is it just picked out at random, like the normal jury, or? So
my understanding, having not actually gone through the process on the receiving end and having not had to like send out, so this is probably also worth noting, I've never convened a grand jury. Grand juries are convened by the courts, and then kind of curiously managed depending on the setup by a member of the district attorney's office or the attorney general's office. The prosecutorial authority will kind of help manage the grand jury, even though it's been convened by the court. There's kind of an interesting relationship there. So you get this group of people, and they're going to be impaneled the same way as another jury. But what's really interesting is that if someone shows up for jury duty and it's a grand jury, you're going to be there for a while, because grand juries, depending on when they meet, like
the
in New
rest
Hampshire,
of the day, or
6 months. A couple times a week so in New Hampshire, I think it was, you'd have it for like the first week of the month for 3 months was how I remember we used to do it. When I was at the AG's office, the special grand jury was sat for 6 months. And so they would be required to come in, at various intervals, regularly scheduled intervals for a 6-month period. And people can sometimes,
do you get a law degree at the end of that, or?
Yeah, I wish, right? And I mean, it's a big ask, and you see a lot of cases. That's the other thing, right? Like you get a grand jury is not convened, for one case. A grand jury, this is another interesting point, right? This is probably a worthwhile distinction. Petit jury is put together for one trial, but a grand jury is going to sit for a period of time and hear as many cases as come through. One of the things that can happen is even though they sit for a long time, you may not finish your investigation in 3 to 6 months. And so you
Right.
have to vote over the investigation to a new grand jury. And then you got to tell the new grand jury, here's a bunch of evidence that was before the last grand jury. You need to get the transcripts, which is an important point. In New Hampshire, there are no transcripts. In Massachusetts, there are recordings which are turned into transcripts, which are turned over to defense attorneys, like as part of initial, they should be as part of initial discovery. And there's value in this because when I was telling you that you present the evidence to the grand jury, or but the investigator is going to present the evidence to the grand jury.
So let me cut in right there real quick,
Yeah,
so we can paint a picture of like the room
Please.
here. So it's like 20 something people, and the prosecutor, is standing in front of them, or Chris back in the day was standing in front of them. Is there anyone else in the room? Is it in the courtroom? Is it in like a side room? Like who's in the room? What kind of room is it?
It looks like a classroom in my experience, almost always.
Okay.
And they come in all shapes and sizes. I think federally they look more like courtrooms, and they may be courtrooms in every state grand jury. And I think I probably was in front of like 4 or 5, maybe more than that. And the one in New Hampshire that I was always in front of, it basically just looks like a classroom, right? There's a lectern at the front where the prosecutor sits. There's going to be a seat for a witness, usually a bunch of multimedia apparatus so that you can put stuff on a computer and throw it up on a projector screen. Whatever means, again, in Massachusetts, it's being used to record you. Mm-hmm. I think a lot of DA's offices probably still use stenographers actively. And we phased them out while the Attorney General's office phased them out during my tenure there. Like when I left, they had switched to recordings. But so that's that. You asked who's the constituency, right? So you're in what looks like a classroom. A bunch of people. They're usually at chairs hopefully with desks so they can write stuff down. Stenographer is going to be there unless it's a recording. And then what you're probably driving at, no judge, no defense attorney. It's just the prosecutor and the witness. And it's usually going to be a bunch of different witnesses over time, but one at a time. So there's always a grand jury coordinator, like I said, who works for the DA's office. And those people are like, I guess, a clerk of courts in that they control everything from an administrative perspective. So if you're a prosecutor,
so when you get them there.
Yeah.
So you get them there, you're in the classroom. Yep. Prosecutor, witness, PowerPoint up of the evidence. The 20-something grand jurors are there. In the petit jury of a regular criminal trial, they're trying to decide not guilty or guilty. What is this grand jury trying to decide at that point?
Probable cause to indict. Yeah, which again, I mean, is really worth driving home for folks. It's less than 50-50, right? So it's reasonable articulable suspicion, probable cause, preponderance, clear and convincing, beyond a reasonable doubt. And the only one that has a real like statistical association with it or a mathematical one is preponderance, right? It's more likely than not. So 50.1%. Probable cause is below that. So
it's not even likely.
Doesn't have to be more likely than not. Just has to be, something that a reasonable person would believe could have occurred. And so that's why.
And that's why I call it plausible cause, ladies and gentlemen.
Yeah, right. Or where you get the joke about how you could indict a grand jury would indict a ham sandwich is like, I think one, that may be a function of how low the burden is. It may also be a function of how many cases are seen and how little, I mean, this is a really important point. This is because a lot of folks I think would be pretty upset to find like, look, there's no counterbalance here. This is just a prosecutor saying and the detective saying I did a bunch of illegal stuff. When do I get to present my case?
Well, so let's go to that topic right here, because we've been covering the theory and kind of like how it works, the process, but like let's take it from somebody's perspective who you just got a grand jury subpoena. Mm-hmm. They call us. What's the first thing we're going to tell them?
If you get a grand jury subpoena, you're a witness and you're being basically requested to appear to give testimony. So if that happens, if you think you might be implicated in some way, you should call a lawyer because you have the right to have counsel advise you. It becomes a very different scenario because they basically just sit there while you testify and they don't really have a role. I guess the idea is that if intervention was required, they're there to try and protect your interests. I'll be perfectly honest with you.
Can the attorney object?
I don't believe that they can object. I think they could probably try to halt proceedings on Fifth Amendment grounds, and then you would be brought in front of a judge to sort of vet that. In all the time I spent in front of a grand jury, I've never had a defense attorney in the room with me.
Wow. Okay.
And not once. I've heard of it.
And
I mean,
can
I
you
know
just
it
say,
happens. It's just
I'm not coming? Like what happens if I just said like I'm not coming? I'm not
You
going to the
can,
grand jury.
and then the depending on how invested the prosecutor is in getting your testimony, they can try to get a judge to order your appearance, at which point you could be brought in handcuffs, theoretically. It's not common, and
Okay.
it's
So
I think for
it's
policy
required.
reasons,
It's
not
not
per
an
se.
ask.
So a subpoena is not an ask. It is a
Okay.
demand, and you can, if you ignore it, there is process to drag you in.
Okay. All right.
And
So if you get one of these, don't ignore it and give a law firm a call.
yeah, I mean, it's probably in your best
Okay.
interest because, like, look, maybe
Okay.
nothing happens to you if you ignore it, but then again, maybe something does happen, and they, if the prosecutor really wants your testimony, do you want a sheriff's deputy showing up and serving you with a court order at that point? What I wonder, if you were chewing around the edges of this, is most folks, again, are not going to know they've been indicted until they've been indicted because there are like secrecy rules around grand jury.
Yeah.
Now, obviously, there are going to be exceptions to this. Like, I had a case where at the very end of the invest, I just needed to rule out a particular theory of defense. And I brought a family member of the defendant in to testify. And that person immediately told the target of the investigation, but we knew at that point that that was probably inevitable. And in that case, they're going to know, okay, there's a grand jury investigation going on against me. But again, more often, I think than not, a person does not look. If you're sitting in jail, sometimes they'll say, like we talked about the immediate crimes, right? Like you're in district court, or maybe you've been held without bail pending indictment. Like, the indictment's coming. Right? Like that's if you've been arrested at the scene or whatever, you're already in custody. You've already aware of process. You know the indictment's coming because the offense is extremely serious. It's not going to be tried in district court. So the other animal, though, the one I'm more familiar with, is where you would simply find out you'd been indicted. You would get a summons to court. You have been charged with the following crime. You are due in court on X date for arraignment. There is another way that it goes, though, which is that if the prosecutor can make an argument to a judge that, and is willing to make the argument that you might be a flight risk, you might not show up, or the investigations reveal that you pose a danger to yourself or to the public, you can get an indictment warrant, in which case, and this is probably the scariest thing to consider, is that you won't know you've been indicted until you are in handcuffs.
Wow.
And then, generally, if they're going to seek an indictment warrant, the government's going to try and get you held on some kind of bail, right? Because to justify the warrant, there's going to have to be some evidence that would require a bail of some kind, if it's going to be cash bail or if it's going to be a no bail hold. If you get a summons that you've been indicted, you should immediately call an attorney, because indictments are very serious. Like, again, you're going to be in superior court. Like and it's going to be a process. So call a lawyer when you get a grand jury summons.
Excellent advice. So I'm just curious now, because it sounds like, the indictment's super low bar, right? And you said that the joke about a prosecutor could indict a ham sandwich. Have you ever seen a grand jury refuse to indict anyone?
I think I've heard of them, but I'm trying to remember the last one I actually saw. It's called getting.
I've heard of something like that happening.
Right,
that's wild.
But it's extremely uncommon, and I mean, there are a couple of reasons for that. And the ones that you hear about more recently, without getting political, is that I think that the guy who threw a sandwich at an ICE agent or maybe an FBI agent down in DC got what they call no bill, because when a grand jury returns the indictment as like, we are indicting this person, we sign off. It's called getting a true bill. And if you get no true billed or no billed, it means that they declined to indict. And because the bar is so low, there's got to be a pretty good reason, right? Like, you had to produce basically no evidence, or the evidence had to be a terrible fit for the crime, or there's kind of a nullification going on, like the sandwich guy I mentioned, where it's like the grand jury was like, we're not indicting this guy.
Explain that.
Go ahead. Yeah, please.
No, you go ahead and explain nullification, unless you'd like.
So nullification meaning the jury, and this happens in petit juries and grand juries alike, they heard everything you had to say, and they may have believed every word of it, and they were like, this is government overreach. We're not applying the law in this circumstance. We are nullifying. And I mean, it's kind of a crazy thing.
So they're saying basically, yeah, you're guilty, but we're gonna ignore that. Like, we're gonna ignore what the law says, because we are this independent power.
If you don't, I mean, if a no bill comes out and it's not because of nullification, it means you did not present enough evidence to support probable cause, which is so insanely low that
Right.
I wouldn't call it misconduct, but it's a mark of incompetence that, I mean, getting no bill is embarrassing, right? Because it's
Right.
like either
Yeah.
either they thought you were unjustified in bringing these charges, or they thought you didn't have enough evidence to support them. And like, again, you had the grand jury at your disposal. You could have pulled records. You could have ordered witnesses to
Right.
appear. You had so many ways, and you're not, I mean, you are bound by certain ethical standards, you're bound by certain protocols, and there's guidance on how to conduct grand jury investigations. But like, there's not a judge telling you you can't do this in most circumstances. Is not going to be. So like, you weren't able to muster enough evidence for this. Like, why did you put an indictment in front of these folks?
Right.
And I'll tell you what,
Right.
this has happened. I had cases like this where,
Okay.
and this, I think this is a good place to mention this. I had cases where, we do the grand jury invest because it looks like, yeah, this person's, I almost certainly committed, and this was a more common one, benefits fraud. They pretended to be injured when they weren't injured. They defrauded the government of a bunch of money. And those are extremely hard to prove because it gets to, and they're mostly pursued civilly, not criminally. Because how do you prove someone's not in crippling pain? Subjective. So I've had cases where we go through the invest to see if there's any evidence we can find that the person like lied to their doctor. And I've had cases that were really close calls, but we don't go forward. Because look, you don't, I mean, if you don't have it, you don't have it. And the last thing you want, frankly, is to get a true bill when you don't have it. Because then you're going to wind up in court and you're going to get a motion to dismiss, which is, I mean, this is probably a good jumping off point to talk about what a defense attorney can do in light of the grand jury process in Massachusetts is when someone's indicted and arraigned and discoveries provided, there's going to be a stack of transcripts from the grand jury.
Okay.
What I told you is that the grand jury transcripts are going to include all the testimony in the order it occurred. So it's going to have the prosecutor's questions and the witness's answers on the date they were presented. Any exhibits are going to be provided. So you're going to have...
it's secret, but you get it all when the case starts.
You get it all when the case starts, and it's a roadmap for how the prosecution got a grand jury to agree to indict.
That's interesting.
So it's a good starting point. But more importantly, if you have an attorney who knows what they're doing, or somebody who used to put cases like this together, like me, you're going to look at this and say, okay, well, I mean, this is a complex issue, right? Like a good example is money laundering. It's just the money laundering statute, which I could talk about endlessly, is like less than 15 years old in Massachusetts. It's a very new statute. So it's not super robustly used. There's not a lot of case law on it. I think that's changing. If a prosecutor, and this is where case law is made, someone brings a case for money laundering and they put together evidence and a grand jury goes, yeah, I guess, right? I mean, like we're not legal scholars, but that seems like it fits. And then somebody like me who did a lot of work on money laundering is going to look through the grand jury transcript and say, nope, this isn't money laundering. Like, I know why you thought it was, but it's not. And so I'm going to have a motion to dismiss. This case is going to get kicked away. And, there are competing strategic considerations to doing that because they could just try to fix it and come back again. Jeopardy's not going to attach unless there's a jury sworn, like a petit jury. So the point is that you get a lot as a defendant when you're indicted. And an attorney knows what they're doing, can make a lot from that. They're going to learn a lot about the case. They're going to learn what holes there may be in the case. And I mean, you and I talked about this on a recent podcast. There could be inconsistent statements from witnesses. So when these witnesses eventually testify at a suppression hearing or at a trial, if their testimony deviates substantially from what they said in prior sworn testimony, because it's something I left out, it was one of the funnier parts of the job for me. There's nobody else in the room, so I have to swear in the witnesses. This is the funnier. When I was a baby prosecutor in New Hampshire, like I had to be like, "Do you swear to tell the truth, the whole truth, nothing but the truth, under the pains and penalties of perjury?" I do. Please be seated. It was really wild. So you have sworn testimony, and you have exhibits. You have discovery as the government thinks it's going to be useful in their case. So it gives you a lot of information.
All right, perfect.
I feel like there's so much more in grand jury that I could talk about. But
we could
what
probably
am I
go
leaving
another 2 hours.
Well, that's my problem.
I feel like you've been hitting all the major points. What you just described, explained was very important. Is there anything else on grand juries you think people should know that we haven't covered yet, just kind of off the top of your head? Now that
I mean, it would I think it would surprise people how old-fashioned the process is. And the way,
Okay.
what I mean when I say that, because as an assistant attorney general, so I didn't talk about the statewide. You could probably do a whole other podcast on the statewide. If a grand jury investigation touches multiple counties, you are in a position to ask the Chief Justice of the Suffolk County's Superior Court for permission to use the statewide grand jury, which sits for 6 months because it deals with more complex cases that span multiple jurisdictions. And then you indict, and then you basically pick the jurisdiction that you think that makes the most sense. And that's in the Superior Courthouse in Boston, the Suffolk Superior Courthouse. And the special grand jury is maintained by the Attorney General's office. There are grand juries maintained domestically at all the other counties, and they all have their own peculiar preferences. And some of them, it's like, unless this has changed since I left the practice, your indictments, I think it's in Essex County, need to be double-sided. And if they're not double-sided, they're gonna make you do them again. And they're very helpful to people I worked with there when I had to. And then in some counties, it needs to be on cream-colored paper. I don't know why. And the form of the thing is going to have like cursive on it in certain cases. It's really wild. And like, it's hard. It was a challenge as an assistant attorney general being like shipped off to different jurisdictions. Like I had a couple of indictments that I tried to put together in like Fall River. So I'm driving way, way south in Massachusetts. And I'm in nobody knows me in this courthouse. I don't know any of the prosecutors, and they're the ones who are hosting the grand jury. And they're like, "Where's your cream colored paper?" Whatever the heck it is. It's like I didn't know that I needed this to be like. So that's why it's a really deliberative and intensive process. And I think it's the fact that it's secretive. I think probably spooks people a lot because like the idea this could be happening and you wouldn't know it is And then there's, as a prosecutor, they got to be considerations about whether it stays covert or becomes an overt investigation. Like you notify the defendant. I've heard people will invite defendants into grand jury to ask them if they want to testify. Sometimes they do. I've had it offered. And it's just a balancing act. So that's the grand jury is a wild tool for investigating, and then if it is merited, for indicting. And that's the beginning of the process in superior courts. You're dealing with usually more serious felonies at that point. I know we could keep going, Bill, but I appreciate you keeping me kind of contained and keeping me on script to the extent that we can.
I think this is this was the perfect introduction to grand juries on this episode of Boston Barristers. If you guys got questions or you want to see grand jury episode number 2, you let us know and we can do that.
If you haven't had enough of the topic already, leave us something in the comments.
Yeah. But if you or someone is dealing with a grand jury subpoena in investigation or any criminal matter in Massachusetts, please give us a call. We are here to help. And if you liked what you heard today, subscribe wherever you get your podcasts, and please leave us a review if you can, because it really does help other people find this podcast and can go a long way to helping people get out of their legal troubles. So you can also find us online for more resources on our website, www.mwpetersonlaw.com. You can see our blogs there as well. Thank you again. Happy New Year. I'm Bill Manchinton with Chris O'Brien. Thanks for listening, and we'll see you next time.